Hello everyone, this is your host Urvashi Chauhan. Welcome to Courts Today by Livelaw, your one-step destination to all legal developments in the country. Let us start. Starting with an update from the Delhi High Court, which today issued notice on the plea moved by Delhi Chief Minister Arvind Kejriwal, challenging his arrest as well as the CBI remand of 3 days in the corruption case related to the alleged liquor policy scam. Kejriwal is in judicial custody in the corruption and money laundering cases related to the alleged scam. He approached the High Court after the CBI arrested him last week. He was remanded to CBI custody for 3 days on 26th June by Vacation Judge Amitabh Rawat, observing that the arrest at this stage could not be said to be illegal. Kejriwal has contended that his arrest was unlawful because the investigating officer did not follow the legal requirement to issue a notice as mandated by sections 41A and 60A of the CRPC, despite the offence being punishable by 7 years. His counsel today submitted that there was no urgency or necessity of arrest in the case, as Kejriwal was arrested in the FIR registered by CBI in August 2022, where he was called for questioning only once in April last year, to which he cooperated. The counsel further took the court through the arrest memo prepared by CBI and said that it did not satisfy the conditions as mentioned in law. Kejriwal has also sought his immediate release in the corruption case. The bench of Justice Neena Bansal Krishna heard the matter today and sought response of the probe agency. The matter has now been listed for hearing on 17th July. Stay tuned. The Bombay High Court today continued hearing the petitions filed by comedian Kunal Kamra and others challenging Rule 3 of the Information Technology Intermediary Guidelines and Digital Media Ethics Code Rules of 2021. Under the new rules, social media platforms must try to stop users from sharing information deemed fake or misleading by the government's fact-checking unit or the FCU regarding central government business. Kamra, a political satirist who uses social media to share his content, argues that these rules could lead to his content being blocked, taken down, or his account suspended without fair reason. If you remember, this case was assigned to Justice A.S. Chandorkar after a split decision by Justices Gautam Patel and Neena Gokhale. While Justice Patel held that the rule should be struck down in its entirety, Justice Gokhale held that the rule was lawful. Their opinions clashed on all the points. In this matter, the petitioners already concluded their arguments in April this year, contending that the purpose of the FCU was to bring total state censorship on anything that the government does not want people to know, discuss, debate, or question. Yesterday, the central government in this matter told the court that failure to prevent fake or false news would violate the fundamental right of the recipient of such news to know correct information and not be misled, which also flows from Article 19(1)(a) of the Constitution. Today, Solicitor General Tushar Mehta mentioned that several entities, including state governments like Kerala and Uttarakhand, as well as private organizations like Times Fact Check and Webcoof, have their own fact-checking units. These entities collaborate with intermediaries to identify and flag false information. For instance, he gave the example of a viral tweet falsely claiming that 80,000 Indian soldiers had applied for sick leave during a face-off with China. In such cases, he said the government informs the intermediary platforms that the information is false and that the appropriate action be taken by them. He emphasized that identifying something as fake does not require a strict definition. When something is labeled as fake, it means it never existed, whereas false information refers to facts not supported by government records. Let me give you an international update. In a landmark decision, the United States Supreme Court has ruled that former President Donald J. Trump has absolute immunity from criminal prosecution for actions taken within his constitutional authority during his presidency. The court also stated that he has at least presumptive immunity from prosecution for all his official acts. This decision stems from Trump being charged with attempting to overturn the results of November 2020 US elections by spreading false claims of election fraud. Trump had argued that as a former president, he should be completely protected from being prosecuted for actions he took while in the office. The lower courts had rejected Trump's argument, saying that former presidents do not have blanket protection from criminal charges. However, both the courts had not decided if Trump's actions were part of his official duties as the president or not. The Supreme Court has now clarified that there was no immunity for unofficial acts. The case has been returned to the lower court, which will decide whether the actions Trump took were in an official capacity or not. While noting that this case was the first criminal prosecution of a former president for actions taken during his presidency in the US history, the court remarked that it was essential to carefully assess the scope of presidential power under the US Constitution. The court cited Article 2 of the Constitution, which vests executive power in the president as the basis for this immunity. It further stated that under the constitutional structure of separated powers, such an immunity was bound to be provided. This ruling could impact how future presidents and former presidents are held accountable for their actions while they were in office. It can be argued that this ruling may provide excessive protection to presidents, potentially shielding them from legal consequences of criminal acts committed by them while in office. To read more on this, you can visit livelaw.in. As you know, the 3 new criminal laws are now in force. While the government claims these changes are necessary to decolonize Indian criminal law, critics argue that the substance remains largely unchanged with only superficial modifications. Amidst various doubts surrounding the new laws, a plea has been filed in the Madras High Court seeking to declare the Hindi names of the new criminal laws as ultra vires the Constitution, the Official Language Act of 1963 and the Tamil Nadu Official Language Act of 1956. The petition filed by a lawyer seeks directions to the Cabinet Secretariat, Home Secretary and the Law Secretary to take appropriate steps to provide English nomenclature for the new criminal laws. In his plea, he has submitted that the union government has given Hindi and Sanskrit names to the new criminal laws. He added that out of the 28 states and 8 union territories in the country, only 9 states and 2 union territories have Hindi as their official language. Further, the plea submits that as per Article 348(1)(a) of the Constitution, all proceedings in the Supreme Court and the High Courts are to be in English, and that laws written by the legislatures should be understandable to the average man as well as a legal professional. It is submitted that the petition has been filed in the interest of law students, law teachers, advocates, law officers, judicial officers, and the common public who are not familiar with Hindi and Sanskrit and for whom the new laws would create confusion, ambiguity, and difficulty. He has thus pointed out that Hindi names of the new laws violate the fundamental right to practice any profession of non-Hindi speaking people. The Delhi High Court has observed that criminal cases involving allegations of sexual violence cannot be quashed on the basis of monetary payments, as doing so would imply that justice is for sale. Justice Swarnakant Sharma made the observation while rejecting a plea moved by a rape accused seeking quashing of an FIR registered by a woman on the ground that the matter was amicably settled between the parties and that she agreed to settle her claims for 1.5 lakhs. The court noted that despite serious allegations of extreme sexual violence and threats, the prosecutrix stated that the FIR was lodged out of anger and that she wished that the case be quashed following intervention by their families. It further noted that the MOU entered into by the parties was not the result of a resolution of misunderstandings, but rather an exchange of money amounting to 1.5 lakhs. This was intended to secure the quashing of the FIR. The court stated that the ends of justice will be served not by quashing the FIR without a trial, but by conducting a trial to ascertain the real culprit. And lastly, the Telangana High Court has dismissed the petition moved by former Chief Minister K. Chandrasekhar Rao challenging formation of a one-man commission to look into alleged irregularities arising out of power procurement during his government between the years 2014 to 2023. The Justice L. Narasimha Reddy Commission was formed to probe the correctness and propriety of decision related to the procurement of power from Chhattisgarh, the establishment of Bhadradri Thermal Power Station and the establishment of Yadadri Thermal Power Station. The plea filed by ex-Chief Minister alleged that the commission lacked transparency as it was headed by a retired judge who was allegedly close to the current ruling party, and that in a press conference, the head of the commission had displayed bias. Division Bench of Chief Justice Alok Aradhe and Justice Anil Kumar Jukanti said that mere allegation of bias against Justice Reddy solely based on his statement reportedly made in the press conference cannot be established. The court further held that the contention that state authorities had already adjudicated the matter could not be accepted because, as per the Commission's terms of reference, the issues to be adjudicated by it are far wide. Therefore, the petition was dismissed. If you wish to know more details about the cases that I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.